Thanks to ExpressVPN for keeping LegalEagle's safe and in the air. Despite the dire situation that the world is experiencing because of the COVID-19 pandemic, some people just have to be jerks. Like this guy, Lars, a California, quote, influencer who thought it would be cute to lick a toilet and dub it the Coronavirus Challenge.
Coronavirus Challenge.
He later ended up in the hospital with coronavirus. Lars inspired people like Ava Louise to lick a toilet seat herself. And this other guy, Cody Lee Pfister, filmed himself licking a row of deodorant at Walmart.
Who's scared of coronavirus? Don't touch your mouth.
Pfister was arrested. Or this group of Cincinnati residents who flouted the governor's social distancing orders by throwing a coronavirus party. The legal term for these people is idiots. And what do all of these idiots have in common besides being nominees for the 2020 Darwin Awards? They may have done things that could result in lawsuits or even jail time. Hey Legal Eagles, it's time to think like a lawyer, because today we're going to talk about a bunch of different cases where people intentionally or knowingly expose others to the novel coronavirus. Like, what happens when someone pulls a prank and coughs on the salad bar? Is it a criminal offense to give someone COVID-19? And what happens if you intentionally try to infect others? I'm here to answer all of these questions and scare you away from ever eating at a restaurant again. Now let's start with the basics of assault and battery. Most causes of action for spreading COVID-19 would probably be on the state level, starting with assault and battery, which are both tort claims and criminal offenses. The same conduct can lead to a personal injury lawsuit and a criminal prosecution, depending on who initiates the case and the severity of the actions that we're talking about here. Battery is generally defined as a harmful or offensive contact with another person's body. Now, the victim's body under this definition is usually extended to include things that the victim is attached to. This is called the extended personality rule. This means grabbing someone's shirt or yanking their necklace or spitting in their cup can also be battery, even if the perpetrator never actually touches the victim's body. Now, purposefully spreading a disease to another person generally fits within the definition of a harmful or offensive touching. It's certainly not something that people want in their everyday lives. For example, in Pennsylvania, a malicious man in a grocery store was arrested after deliberately coughing in the face of an older gentleman wearing a face mask and gloves because of the potential fatal risk of COVID-19. This jerk, or idiot, as we say in the legal profession, allegedly coughed and mocked the man and told him that he was now infected with the virus. This guy was also charged with making terroristic threats as well as battery, and we'll talk about the terrorism charges in just a second. Now, similarly, assault is usually lumped in with battery, but it's technically a separate offense. It's usually the intentional act that causes another person to fear that they're about to suffer physical harm. If a person is placed in imminent fear of bodily harm, this is punishable as a crime or, again, as a tort as well. Imagine you're playing pool with someone in a bar and that person gets angry and swings their pool cue at you. In most places in America, if they make contact, it's battery, but if they swing and miss, that is assault. And you guessed it, this can apply to spreading COVID-19 as well. For example, in Maryland, a man named William Eddings was charged with second-degree assault and 4 counts of exposure by an individual who has an infectious disease in violation of state law after he got in an altercation with one of his father's tenants, screaming and chasing the man into his vehicle, where Eddings spit on his arm twice. When police arrived, Eddings said he had tested positive for COVID-19 and then spat at the officers. Again, not a smart guy here. Now, under Maryland law, assault is defined as an attempt to make an offensive contact with another or intentionally frightening another person. Eddings' saliva actually hit the victim's arm, which is definitely a battery. And although his spit didn't make contact with the officers, spitting in their direction is a clear attempt to scare them, and that was enough for the assault charge. And in this generation where we're worried about droplets of water in the air, it could be argued that even if the main spit, and it's ridiculous that I have to go down to this fact situation, but even if the main wad didn't make contact, even the droplets in the air might qualify as a battery itself. And since assault and battery are also torts, it's conceivable that someone like Eddings could be sued for assault and battery in state court and pay civil damages to the victims here. And Maryland, like many other states, have specific statutes that actually deal with the intentional spreading of infectious diseases, and that's one of the things that this guy was charged with. But I mentioned terroristic threats, and these days most states have a criminal offense called terroristic threats. And this offense is probably not the thing you're thinking of when you hear the word terrorist. It has nothing to do with foreign governments or international elements. This is generally a verbal or written threat to commit an act meant to terrorize another party, when you do that, you can get arrested, not surprisingly. The threat can be paired with an actual crime like battery or murder, but it can also be a general threat meant to terrorize. So, for example, if you called up your high school and made a bomb threat, for instance, if there was no specific statute dealing with bomb threats, you'd probably be charged with making terroristic threats, even if no one was in actual physical apprehension of physical contact, which would be required for assault. Unfortunately, there are many examples of people doing really stupid and dangerous things during this pandemic that probably give rise to a crime of terroristic threats. For example, a New Jersey man was arrested for coughing on a Wegmans employee and telling the woman that he had the coronavirus. The employee said that she was concerned that he was standing too close to the salad bar and she asked him to move. He then coughed on her and laughed and claimed that he had the virus. He was charged with making a terroristic threat. He was also charged with obstruction and harassment. A Texas teenager posted several videos claiming that she had the COVID-19 infection and wanted to kill people with it.
If you want to get the coronavirus, die, call me. And I will meet you up at all over you.
Obviously, the police were concerned and they tracked her down. Now, this is not without controversy. The terrorism laws were intended to apply to terroristic acts to a group of people and generally were not meant to apply to a single individual person talking to another person. But generally, true threats are not considered free speech and not protected by the First Amendment. Though it's still controversial as to whether these statements constitute a true threat or not. So it sort of begs the question, which I'm actually using the correct way this time. But there is precedent for using state terroristic threats to prosecute people for exposing others to infectious diseases. Prosecutors charged individuals with making terroristic threats for exposing their sexual partners to HIV in the 1990s, which led to new statutes specifically directed towards infectious diseases. According to the Center for HIV Law and Policy, roughly 2/3 of states have laws that make it a crime to knowingly expose others to HIV, among other infectious diseases. For example, in April 2012, a 19-year-old man who had HIV was charged with assault and battery with a deadly weapon, among other things, for failing to disclose his HIV status to multiple sexual partners. At least one of his partners later tested positive for HIV. At least 12 states have added hepatitis C to the list of diseases that could cause criminal prosecution if the infected person knowingly exposes other people. Though public health advocates believe legislators should be cautious about passing more laws criminalizing the spread of disease because it can also stigmatize testing and treatment. There are probably fewer issues with adding COVID-19 to the list of diseases that are covered by these disclosure laws, since COVID-19 is easier to transmit than hepatitis C or HIV, and COVID-19 arguably gives prosecutors a better argument for aggressively charging people who threaten to expose others to the virus because of its ease of communication. Now, the state of mind here is always important. Almost all criminal laws have a mental state requirement, or mens rea, or guilty mind component. You can't be criminally prosecuted just because you accidentally infected someone. You have to intentionally or knowingly infect them in situations that give rise to liability. So don't think that anyone who happens to communicate the disease is going to be prosecuted under these laws. But where there is really egregious conduct, the prosecutors are probably going to bring out the big guns.
Time to bring out the big guns.
And one of the most egregious examples of intentionally exposing people to COVID-19 happened when Margaret Serco went to a supermarket and started coughing and spitting on the food. Serco claimed to have the coronavirus and coughed or spit on about $35,000 worth of food, which had to be thrown out. Authorities don't yet know if Serco really had COVID-19, but her actions caused serious losses to the store, in addition to potentially exposing employees and shoppers to the virus. She was arrested and charged with 2 felony counts of terroristic threats, 1 felony count of threats to use a biological agent, and 1 felony count of criminal mischief. It's worth noting that it probably doesn't matter if she actually has the virus or not. For example, if you fire an unloaded gun at someone, but you think that gun is loaded, that still generally qualifies as attempted murder. Now, Serco being cited for threatening to spread a biological agent brings us to whether federal anti-terrorism laws could apply to COVID-19. And on March 24th, Deputy Attorney General Jeffrey Rosen sent U.S. attorneys and federal law enforcement agencies a memo recommending that people who purposefully expose or infect others with COVID-19 should be prosecuted under federal terrorism statutes. Now, there are several federal statutes that the DOJ is considering. The first is 18 U.S.C. USC 2332, which makes it a federal offense to threaten or attempt to use a weapon of mass destruction against persons within the United States. And a weapon of mass destruction is any weapon involving a biological agent, toxin, or vector. And biological agents are defined to include viruses capable of causing death, disease, or other biological malfunction in a human. Now, a defense attorney would probably argue that the statute was intended to apply to artificially created vectors and not the naturally occurring cold viruses or coronaviruses, but the statute is written broadly enough to apply. And despite rumor mongering to the contrary, there is no evidence that COVID-19 was engineered by China as a biological weapon, but the statute probably still brings it under its aegis. Now, Rosen did not mention 18 U.S.C. 1365, which penalizes tampering with consumer products, even though it arguably applies to people like Serco who go around tampering with consumer products. However, this law was used to arrest the mastermind of the biggest bioterrorism attack in US history and could be useful in stopping people from spreading COVID-19. Now, this example is so crazy it probably bears mentioning. In the early 1980s, Bhagwan Rajneesh, also known as Osho, amassed a number of devoted religious followers in India, moved to the United States, took over an Oregon town, fought with the co-founder of Nike, acquired the largest collection of Rolls Royces in the world, violated immigration laws, sedated thousands of homeless people, tried to assassinate public officials, and infected 751 people with salmonella by contaminating 8 restaurant salad bars. The salad bar poisoning was a plan to stop people from voting in a local election. And if you've ever seen the Netflix documentary Wild Wild Country, you've no doubt witnessed Osho's right-hand man, Ma Anand Sheela, memorably justifying the cult's actions.
What can I say? Tough titties.
The Rajneeshis stole the salmonella cultures from a Seattle lab, and Sheela pleaded guilty to conspiring to tamper with consumer products and wiretapping. Federal law makes it a crime to tamper with food by exposing it to toxic chemicals or bacteria or viruses, as the Rajneeshis did in Oregon, not surprisingly. And also there are a bunch of state laws that prohibit tampering with food products as well. Remember this girl who licked a tub of ice cream and then put it back? Well, she was arrested with tampering with food products under a Texas tampering law. And this kind of tampering has been on the federal radar since February, when an FBI briefing disclosed that white supremacists have discussed using COVID-19 as a bioweapon, including leaving saliva on door handles, spitting on elevator buttons, and using some of the same tactics as the Rajneeshis. Now, that's a summary of the sort of criminal acts that you might be charged with if you go around intentionally infecting other people with COVID-19. But what about just walking around or defying a lockdown order? Well, I have a video all about the government's legal authority to isolate and quarantine people during a health crisis. And in that video, I talked about the history of quarantine laws, Typhoid Mary, and the Spanish flu, and the other stuff that happens during a pandemic. And my conclusion was that lawsuits challenging COVID-19 quarantines and restrictions on public gatherings would probably fail because the police power of the states are really at their zenith in situations like this. But what about the liability of people who break those quarantine and isolation orders? Well, we've now witnessed state authorities using their broad powers to issue orders requiring businesses to close, people to remain at home, and sick patients to be isolated and quarantined. But the unique nature of this crisis has governors, mayors, and police making ad hoc decisions about the quarantine. And apart from the criminal liability and potential jail time of defying these orders, you might also be on the hook for damages caused by just people getting sick from your actions. And I think there are a couple avenues here. One is what's called negligence per se. Negligence per se is the law's way of imposing strict liability on specific circumstances. Strict liability is automatic liability. So this means that the defendant is liable regardless of the defendant's intent or what they knew or what they should have known. If strict liability applies, the defendant has to pay for his or her conduct if it caused the plaintiff's injuries. And one of the ways to trigger negligence per se is when you break the law. If you break the law, or there is a statute that says you cannot conduct these particular actions and you go and do that, the law sometimes says that you have to pay for the damage that you caused, regardless of whether you acted negligently or not. So for example, in Connecticut, a woman was injured after a dog that was subject to a 14-day quarantine escaped. The woman sued the local dog warden, and on appeal, the Court of Appeals held that the dog warden could be sued and immunity did not apply because the dog catcher violated the quarantine law. And in a somewhat analogous situation, a Minnesota couple sued a physician they hired to take care of their daughter who had scarlet fever. The physician allowed the parents to visit her and take her home when her disease was at its most contagious, advising them that she wasn't really contagious. The Minnesota Supreme Court found that the doctor could be sued for negligence. So this is a fluid situation. You can probably expect many negligence lawsuits against healthcare facilities, cruise ships, and other businesses if the plaintiff can prove that any of these entities failed to take precautions or violated some law that allowed them to be infected. And the same may be true for employees in high-risk professions or locations who are recklessly exposed to the virus by their employers. And if there's one takeaway here, and I probably shouldn't have to tell you this, but I'm going to tell it to you anyway. You shouldn't lick toilet seats. You shouldn't lick food products. And you shouldn't intentionally spread COVID-19, or you might face legal liability. Dummies. And getting infected with a virus is terrible, whether we're talking about a person or a computer, because surfing the web unprotected is almost as dumb. Which is why I'd recommend ExpressVPN. For those of you who don't know, a VPN basically creates a secure tunnel from whatever device you're using and the internet, keeping your digital privacy intact. And it's a big issue because every time you connect to an unencrypted Wi-Fi network at airports, hotels, coffee shops, remember all of those? Weren't those great? Those were good. Or even at home, you're at risk. ExpressVPN encrypts your internet connections using the highest standards of encryption currently available. And one of the privacy issues in the US is that ISPs often track and sell your browsing habits to advertisers. And in my experience, ExpressVPN is also the fastest VPN by far. And one of the best parts of ExpressVPN is you can also reroute your connection to a server in a country of your choice, giving you unrestricted access to parts of the internet and making geo-restrictions a thing of the past. Take watching Netflix, for example. Say I want to watch my favorite British sci-fi show about a time-traveling alien doctor. I'm a fan. But the selection with me being in the United States isn't like that if I was in the UK. So once I switch my VPN, I can pretty much watch whatever I want, whenever I want. Or maybe I want to see what's trending on YouTube in Belgium or Japan. Apparently I'm huge in Japan. And they also have 24/7 customer support, which means your questions will be answered in seconds, not hours. So if you want to check it out, just head over to expressvpn.com/LegalEagle right now and find out how you can get 3 months free. Again, that's expressvpn/LegalEagle, or just click on the link in the description. Clicking on that link really helps out this channel. So, do you agree with my analysis? Leave your objections in the comments and check out this playlist over here with all of my other analysis about the legal issues raised by COVID-19. And just click on this playlist and I'll see you in court.